I heard the car before I heard anything else. Not the engine, the silence that followed it. The particular stillness of a vehicle that has stopped in front of a house it has no business parking in front of. 6 weeks of living alone had sharpened me in ways I did not ask for. I knew every sound this house made. I knew the difference between wind against the front window and footsteps on the porch. I knew what ordinary silence felt like, and I knew what this was. I looked through the kitchen window and I saw the car. Dark, expensive, Harlan's. My name is Nancy Treadwell. My husband Wendell built everything you are about to hear me fight for. And the morning his twin brother pulled into my driveway, 6 weeks after we buried him, I did not panic. I picked up the phone and I called my attorney. Then I unlocked the front door and I waited. Harlan came in a dark suit. Francine walked behind him the way a woman walks, when she has decided to be present without being responsible. Behind her was a man I did not know. Vincent Gresham, leather briefcase, the careful eyes of someone being paid to watch everything. I let them in without a word. I did not offer coffee. I stood at the edge of the living room with my hands folded, and I watched Harlan cross the floor and lower himself into the chair where Wendell used to sit every Sunday morning with his newspaper and his second cup of coffee. He did that deliberately. I noted it and I said nothing. Before he spoke, Gresham set a document package on the entry table and slid a clipboard toward me. A plain form, formatted like building management paperwork. The kind you sign without reading because it looks like nothing. A receipt, he said, confirming delivery of their materials. I signed it. He initialed his copy, tucked it into his briefcase, and moved on. His mind was already on the primary documents. So was Harlan's. Harlan did not waste time. He said the Treadwell estate, the business, the commercial properties, every account, belonged to the Treadwell bloodline. He said those assets were built on family capital that predated our marriage, and that the law would reflect that. He told me I was welcome to keep my personal belongings. He gave me 30 days to vacate. I let him finish. Then I excused myself, walked to the kitchen, and picked up the manila folder sitting on the counter between the insurance documents and the property inventory sheets. I carried it back into the living room and sat down. Fitzgerald arrived 12 minutes after I called him. He came through the door with the energy of a man ready to dismantle everything Harlan had just said: joint tenancy, trust succession, beneficiary designations. Gresham's team had answers for each one. The room tightened. Fitzgerald's voice climbed slightly. Harlan watched me the way a man watches someone he has already decided does not matter. I waited for a pause in the argument. Then I opened the folder. I began signing page by page, calm and unhurried, the way you sign something you have read many times and understand completely. Fitzgerald's hand came down on my arm. His voice dropped to something I had never heard from him in 11 years. Something close to desperate. He told me I could not do this. He told me to stop. I looked at him without alarm, and I turned to the next page. I signed everyone. When I finished, I heard Harlan exhale, slow, satisfied, the sound of a man receiving confirmation of something he always believed was inevitable. He smiled for the first time since he walked through my door. If you are watching this and you want to know how this ends, drop the time in the comments. I want to know what hour brought you here. I closed the folder. I set it on the coffee table directly in front of Vincent Gresham. I looked at him and I said, "Mr. Gresham, I believe you should read what I signed before anyone celebrates." I had imagined this moment so many times, it had its own texture in my mind. Not the outcome, the moment itself. The specific second, when a man who walked into my home with absolute certainty picks up a document and begins to understand that certainty was the most expensive mistake he ever made. I had imagined Gresham's hands on the folder, the sound of pages turning. I had imagined it until it felt less like anticipation and more like memory. Now it was happening. And I was not nervous. I was watching. He opened the folder with the practiced efficiency of a man who has reviewed hundreds of estate documents. Pen moving, pages turning, expression unchanged. The first several pages were exactly what they appeared to be: asset inventory, property valuations, standard transfer language, dense schedules cross-referenced to supporting exhibits. The kind of estate package lawyers move through quickly once they believe they understand its purpose. His pen moved steadily. Harlan sat back in Wendell's chair with his arms crossed, already composing his victory in his mind. Then Gresham reached Appendix C. The heading read, Asset Valuation Methodology and Transfer Conditions. It looked procedural. Boilerplate valuation language buried behind appraisal schedules and transfer exhibits. The kind of section attorneys skim once they believe the operative terms have already been identified. His pen kept moving for 3 more seconds, then it stopped. He went back 3 pages and read again. The color left his face the way water leaves a cloth when you wring it, not gradually, all at once. I watched it happen and felt nothing except the quiet satisfaction of a woman whose husband told her exactly where to place the operative language and exactly how to structure the packet so a man in a hurry would think he had already found the important pages. Harlan uncrossed his arms. What is it? Gresham did not answer. He read again. The silence in the room changed quality. It became the kind of silence that has weight. Francine shifted in her seat. Fitzgerald, who had been watching Gresham with growing unease, went very still. He had reviewed these documents himself. He was now understanding that he had missed something and did not yet know what. Gresham. Harlan's voice sharpened. Say it in the room. Gresham looked up. He told Harlan they needed to speak privately. Harlan said no. Gresham held his for a moment, the look of a professional calculating whether he had any other option, and then he read the clause aloud. The documents I signed were not a surrender. They were a formal conditional acquisition instrument, a structured offer framework establishing transfer conditions, valuation obligations, and potential purchase liability tied to any executed acceptance sequence connected to the estate package. Fully notarized, timestamped, cross-referenced to the acknowledgement and intake execution pages, signed at entry. Harlan started to speak. Gresham raised one hand and stopped him. He reached into his briefcase and pulled out the clipboard form Harlan had signed in the foyer before he sat down. He set it on the table and read the language aloud, and this time his voice was quieter in the way a lawyer's voice gets quiet when the news is serious. The undersigned acknowledges receipt and review of the enclosed Treadwell Estate transfer documentation package and executes the accompanying intake and conditional acquisition acknowledgement pages attached thereto, including Appendix C, Section 4. Harlan had signed it before he took off his coat, with his attorneys standing beside him. Gresham explained it carefully now, not to persuade Harlan, but because he was already mentally preparing for how a court would read the sequence of events. The acknowledgement alone would not transfer ownership or finalize a transaction of this size, but combined with the attached execution page, the cross-referenced acquisition language, the notarized conditional instruments, and Harlan's documented acknowledgement of review with counsel present, it created a serious contractual exposure issue that no litigation team would dismiss casually. It creates an enforceable dispute, Gresham said carefully. One complicated enough that a court would have to examine how these documents were executed, what was acknowledged, and whether acceptance obligations were triggered by the sequence itself. That is nonsense, Harlan said. Gresham did not respond immediately. His expression told everyone in the room exactly how serious the problem was becoming. Harlan stood up. His voice was controlled, but there was something moving underneath it now. He said he would not pay a single dollar. He said I could take it to every court in Georgia. I kept my hands folded in my lap. I looked at him and I said, that is your right. But there is a second document you have not accounted for yet. I slid the page across the coffee table with one hand. No ceremony, no explanation before he picked it up. My hands were steady, not the steadiness of a woman forcing calm, but the steadiness of a woman who has been ready for this specific moment for a very long time. In a room full of people who had underestimated me since they walked through my door, my hands were the only honest thing anyone could read. Gresham picked up the page. When he first opened the folder, his face had gone pale. Pale is surprise, the reaction of a man who finds something he did not expect. This time his face went completely still, and still is something different. Still is a lawyer sitting inside the full shape of what he missed, measuring every dimension of it, understanding that there is no version of this room where he did not miss it. I let the stillness hold for a moment, then I spoke, not to Gresham, to Harlan. I told him the page he was looking at was the executed intake acknowledgement attached to the conditional acquisition framework he signed on the clipboard in my foyer before he sat down in my living room. I told him the form was prepared by a licensed Georgia estate attorney named Cedric Holloway, and intentionally formatted to resemble the kind of administrative intake paperwork used in commercial property offices. The kind attorneys process quickly once they believe they have already identified the operative transaction documents. I told him the language on that form did more than acknowledge receipt. It cross-referenced the acquisition provisions themselves, the execution page attached to Appendix C, and the transfer conditions incorporated into the estate package. Gresham had signed his own copy, initialed it, tucked it into his briefcase, with his attention already moving toward the larger valuation schedules and estate exhibits. Because nothing about the packet suggested a hidden ambush. It suggested a dense estate structure assembled by lawyers who expected it to be reviewed carefully over time. Not in a grieving widow's living room with Harlan already behaving like the outcome was settled. Fitzgerald had not spoken since Gresham began reading. He was watching me the way a man watches someone he believed he understood, replaying every assumption, finding the gaps. 11 years of working together, and he was sitting across from a woman he was only now beginning to actually see. Harlan stood up. He said it was fraud. He said I had buried language deliberately to trap him. He said no legitimate agreement worked this way, and he would not stand in my house pretending otherwise. His voice had the particular quality of a man whose certainty has curdled into anger, because anger is the only place left to go. I let him finish. Then I told him, in the same tone I had used since I unlocked the front door that morning, that every document in that package was prepared by a licensed Georgia attorney, witnessed, notarized, timestamped, and integrated through cross-reference provisions commonly used in large estate and commercial transactions. I told him the issue was no longer whether he liked the documents. The issue was whether a court would conclude he reviewed and executed enough of the structure knowingly enough to create contractual exposure serious enough to litigate. That landed differently. Not because it sounded dramatic, because it sounded legal. I told him Wendell knew about every page. I let that settle into the room. Then I told him Wendell helped design every page. The room changed when I said that. Not dramatically, no one moved. But something shifted in the air, the way it shifts when a dead man walks back into a conversation, and everyone realizes he never actually left. Francine spoke for the first time. Her voice was careful, deliberate, the way a woman speaks when she is choosing footing on ground she is no longer sure of. She asked me if this meant they actually owed me money for the estate. I looked at her for a moment. I said, "It means your husband made a decision when he walked through my door. I simply made sure that decision came with consequences he did not expect." Harlan told Gresham to begin a fraud challenge immediately. Gresham did not move. He told Harlan quietly that challenging the documents and defeating them were not the same thing. He said the structure was aggressive, heavily integrated, and professionally assembled. Then he said something I watched Harlan visibly dislike hearing. "A court may ultimately reject parts of it," he said carefully, "but that is not the same thing as making it disappear quickly." Then he told him they needed to speak privately before any next steps. The meeting ended without resolution, without agreement, without anything Harlan came there to leave with. He did not look at me when he walked out. Francine did. When the door closed, Fitzgerald sat down across from me at the kitchen table. The house had gone quiet, the way it goes quiet, when something enormous has just passed through it. He looked at me for a long moment. Then he asked how long I had been planning this. I looked at the chair across the room, the one Harlan had sat in, the one that still belonged to Wendell in every way that mattered, and I said, "Since the day my husband told me his brother had been waiting for him to die." After they left, the house went quiet in a way I had not felt before. Not the silence I had been living in for 6 weeks. That silence I knew. That one had weight and texture, and the particular hollowness of a house built for two that was now holding one. This was different. This was the silence of a house that had just held something enormous, and was settling back into itself, the way a room settles after a storm has moved through it and taken everything it came for. I made coffee. Fitzgerald sat at the kitchen table and waited. I told him everything. 14 months before Wendell died, he received his diagnosis. He told me first, before his doctors had finished explaining the full prognosis, before anyone else in the family knew there was anything to know. That same week, he called Cedric Holloway. I explained to Fitzgerald who Cedric was, because the distinction mattered. Cedric was not my attorney. He was Wendell's, the man who had handled the Treadwell business structures and estate planning for 11 years. Fitzgerald was my litigation counsel, brought in specifically for what happened that morning. They worked in separate lanes. That was never an accident. Over the 14 months that followed, Wendell and Cedric restructured everything methodically. The house had always been joint tenancy. No change needed there. It passed to me automatically the moment Wendell died. The business was moved into a living trust, with me as sole successor trustee and sole beneficiary. Every account was either jointly held or had me named as the designated beneficiary. When Wendell died, not a single asset passed through probate. There was nothing for Harlan to legally contest. That was the foundation, built quietly, documented carefully, finished before Wendell ever told me how little time he had left. The conditional transfer document was Wendell's idea, not the legal construction. That was Cedric, but the principle behind it. Wendell told Cedric that Harlan would come. He said he had watched his brothers his entire life, and he knew exactly how that man moved when he believed an opportunity was within reach. He said they needed something that would let Harlan feel like he was winning just long enough to commit himself fully. I described the nights at this same kitchen table. Wendell in his robe after treatments, Cedric with his yellow legal pad, the two of them going through every page while I sat beside them. Wendell made me walk through the acknowledgement procedure until I could do it from memory. How to hold the clipboard. Casually, the way you hand someone a form that means nothing. How to time it so Gresham's attention was already moving toward the main documents before his pen touched the line. How to make it look so administrative that a lawyer's instinct to protect his client would not fire. He told me, when Harlan comes, and he will come, I need you to let him feel like he's winning long enough. Fitzgerald was quiet for a moment. Then he asked why she had not told him. I told him his panic needed to be real. A lawyer who is not alarmed when his client begins signing away an estate is a lawyer who knows something. Gresham needed to see genuine distress from my own attorney. So did Harlan. If Fitzgerald had been calm that morning, the entire room would have shifted. Everything depended on his reaction being exactly what it was. He sat back in his chair. He looked at the table for a long time. Then he said he had practiced law for 20 years and had never seen a more complete estate protection structure built around a single anticipated event. I told him Wendell was thorough in everything he did. In everything. Fitzgerald's phone rang. He answered it, listened, and said nothing for several seconds. When he lowered the phone, his expression had the particular stillness of a professional reclassifying a situation in real time. He told me that Harlan Treadwell had filed a civil suit in Fulton County Court. Fraud, document manipulation, intentional misrepresentation. We had been served. The lawsuit documents arrived the following morning. I read them at Wendell's desk, the same desk where he used to review lease agreements and quarterly reports, and every document that built the empire Harlan was now trying to take through a court filing. I sat in his chair and I read every page: fraud, undue influence, intentional concealment of material terms. I read the allegations the way you read something written by a man who has confused his anger for a legal argument, specific, detailed, and wrong in exactly the ways an entitled person is wrong. The particular irony was not lost on me. Harlan had no legal claim to this estate before he walked through my door. The house transferred to me automatically. The business was protected inside a trust. Every account had my name on it. He had nothing to contest. So he was contesting the documents that proved it, arguing the protection itself was fraudulent. It was the only door available to him, and he had walked through it. Fitzgerald and Cedric came to the house that afternoon. I had spoken about Cedric Holloway, but the audience had not yet met him in person. He arrived with a single leather portfolio, sat down at the kitchen table, and read Harlan's complaint in complete silence. When he finished, he set it down and identified 3 problems with it, without referring back to a single page. First, every document in the package was properly executed, witnessed, notarized, and time-stamped. Second, Harlan signed the acknowledgement form voluntarily, with his own attorney standing beside him. Third, a fraud claim requires proof that a document misrepresented something material. The conditional transfer document stated it's accurately. Those terms were unfavorable to Harlan. Unfavorable terms are not fraud. They are a contract he did not read carefully enough. Then, Cedric said the thing that changed the temperature in the room. He told me that Harlan filing this lawsuit was the best thing he could have done for my position. Discovery works in both directions. Now we could compel Harlan to open his financial records, his private communications, and every business dealing connected to his claims about the Treadwell estate. Everything he had been telling banks and business partners and tenants about ownership of this estate was going to have to come out under oath in a Georgia courtroom. I asked what we did now. Fitzgerald said we prepare. Cedric closed his portfolio and said we wait. He looked at me across Wendell's kitchen table and said a greedy man in a courtroom always gives you more than you came for. They left before evening. I made dinner I did not eat and sat with the quiet the house had settled back into. Then Paulette called. Paulette Merriweather had been my closest friend for over 30 years, and her network was the kind that heard things before they were meant to be heard. She told me she had gotten the same information from 3 separate people within the same afternoon. Harlan had already been contacting Wendell's commercial tenants. He was sending letters on unofficial letterhead, identifying himself as the new property manager, and directing rent payments to a personal account. One tenant, confused enough to question it, had called Treadwell Property Group's main office directly and spoken to my office manager that same day. I thanked her and I hung up. I walked to the living room and I sat down in Wendell's chair. The lights were off. The street outside was doing what streets do at that hour. Quiet movement, distant sounds, the ordinary business of a world that did not know or care what was happening inside this house. The man had filed a lawsuit against me that morning for documents he claimed were deceptive. That same afternoon, he was collecting rent checks from properties that did not belong to him. I sat with that. Not with rage. Rage would have been easier. What I felt was colder than rage and cleaner. It was the particular recognition that comes when a person removes every remaining doubt about who they are. Harlan had just shown me exactly what he was willing to do, and exactly how far he intended to go. By the next morning, I had confirmed everything Paulette told me. 2 of Wendell's long-term commercial tenants had received letters. Unofficial letterhead, not Treadwell Property Group stationery. Not anything with legal standing behind it, just Harlan Treadwell's name at the top and his instructions below. He had identified himself as the new property manager and directed all future rent payments to a personal account. One tenant had already sent a check. It had already cleared. I sat with that for a while. Not with outrage. Outrage would have made it personal, and this was not personal. This was information. A man who had filed a lawsuit against me that morning for documents he claimed were deceptive was simultaneously collecting revenue from properties whose ownership was actively disputed in his own filing. That was not just audacity. In the right hands, it was a document, and I knew exactly whose hands to put it in. I brought everything to Cedric: the letters, the account information, confirmation of the cleared check. He read through each page without expression. Then he closed the folder, picked up his phone, and told me he was filing an emergency motion that afternoon. Cedric filed for a restraining order in Fulton County Court, asking the court to immediately freeze all financial transactions involving Treadwell Property Group assets until the litigation was resolved. The motion attached the tenant letters as exhibits. It documented the redirected payments. It documented the check that had cleared. It laid out plainly what Harlan had done: collected money from disputed assets while his own lawsuit was still pending. Judge Warren Dupree granted the TRO the following morning. A preliminary injunction hearing was scheduled within 14 days. I had never been inside a courtroom for this matter before that hearing. I want to describe it not as a room but as a moment, the specific feeling of sitting on one side of something and watching the other side try to explain behavior that does not have a clean explanation. Gresham argued the TRO was premature. He said the tenant letters were a misunderstanding, that Harlan had acted in good faith based on his genuine belief in his ownership position. He said the motion was an overreach designed to embarrass his client during active litigation. Cedric set the tenant letters on the table, the redirected account documentation beside them, the cleared check beside that. Judge Dupree looked at the materials. Then he looked at Gresham with the particular patience of a man who has heard many explanations and developed a reliable sense for which ones hold weight. He said that a plaintiff collecting revenue from assets whose ownership is actively disputed in his own filed lawsuit, raised concerns extending well beyond the scope of the original complaint. He converted the TRO to a preliminary injunction. Harlan was ordered to cease all contact with Treadwell tenants immediately and return every dollar collected. Harlan sat at the plaintiff's table, looking like a man who had walked into a room expecting a different room entirely and could not locate the exit. After the hearing, Gresham pulled him to the side of the corridor. I watched from across the marble floor. I could not hear the conversation. I did not need to. 31 years of reading rooms had taught me everything I needed to know about a man receiving news his body refuses before his mind accepts it. Gresham's posture said counsel. Harlan's shoulders said no. His jaw said no before he opened his mouth. Whatever words followed were only confirmation of what his body had already decided. I walked to my car alone. I sat in the driver's seat without starting the engine. I thought about something Wendell told me years ago, that the most dangerous thing about his brother was never the greed. Greed could be managed, anticipated, redirected. What made Harlan dangerous was his absolute certainty that the rules existed for other people. He had just demonstrated that certainty in open court, and he still did not see it. Let me explain what discovery means, because what happened next matters, and I want you to understand it fully. When a civil lawsuit is filed in Georgia, both sides are required to disclose financial records, private communications, and every document relevant to the claims being made. Not the documents they choose to share. Everything. Harlan had opened a courtroom door believing it would lead to my undoing. What he did not calculate was that the same door opened from both sides. His team requested my estate documents first. They were looking for the irregularities they needed. Inconsistent dates, unwitnessed signatures, language that could be characterized as deliberately misleading. They found nothing. Every document clean, every date verified, every signature witnessed, notarized, and timestamped across 14 months of careful preparation. Cedric had not built those papers to survive a casual review. He had built them to survive exactly this, a hostile legal team looking for any thread they could pull. There were no threads. Then we requested Harlan's financial records and related communications tied to his ownership claims. Cedric brought the disclosure to my kitchen table. The morning it arrived, I sat across from him and watched him work, the quiet efficiency of a man who knows precisely what he is looking for and has the patience to find it without announcing the search. His yellow legal pad filled slowly. He did not speak. He marked pages. He turned back. He marked again. The production itself was massive. Bank statements, brokerage records, internal correspondence, email exports assembled by Harlan's legal team from multiple accounts and devices. Much of it had clearly been processed through broad electronic collection searches before privileged review and narrowing. Cedric noticed that immediately. So did Fitzgerald. The disclosure had volume but not precision. That usually meant somebody was moving too fast. After a long while, Cedric set the pad down and looked at me over his glasses. Harlan Treadwell's finances were significantly worse than anyone outside his household knew. Credit lines at their absolute maximums. A second mortgage on his home. Taken out 18 months ago, around the time Wendell's declining health first became visible within the family. Investment accounts that should have held decades of careful management were nearly empty. The picture resembling itself from those pages was not the picture of a wealthy man asserting his rightful inheritance. It was the picture of a man who had begun financially positioning himself around his brother's death before his brother was finished living. I sat with that. Wendell had been in his treatments. He had been fighting. And across town, his twin brother had been at a bank signing papers on a second mortgage. Then Cedric found the emails. Communications between Harlan and a contact at a commercial property brokerage, dated 4 months before Wendell died, at a time when Wendell was still running the business, still sharp, still present. The emails showed Harlan inquiring about listing procedures for 2 of the Treadwell commercial properties. He was already mapping out how to liquidate what did not belong to him. He was already treating the inheritance as settled before his brother had drawn his last breath. Cedric marked those pages separately. Then he went still. He read something twice without speaking. He did not look up. He did not offer commentary. He simply slid the page across the table toward me. It was an email from Harlan to the same contact. It asked how quickly assets could be moved out of a trust structure if the trustee became. And Harlan used this exact word, incapacitated. I want the audience to understand what I understood the moment I read that word. Wendell was the current trustee, but Wendell was dying. That was already in motion. The trustee Harlan would need to remove after Wendell was gone. The only person standing between him and everything inside that trust was me. He was not asking about a legal process in the abstract. He was asking about me. He was researching how to remove me before I ever became an obstacle. This was not a man who had simply hoped to inherit. This was a man who had been planning to take. Cedric closed the folder. He told me, in the same unbothered tone he used for everything, that Harlan's legal team likely had not fully understood what had been swept into the initial production set before disclosure review was finalized. Then he told me we were going to request every communication in that thread, and that Harlan was going to have to decide what he was willing to let a Georgia court see. I did not sleep well that night, but I did not spend it in feeling. I spent it in deciding. By the time Fitzgerald and Cedric sat down across from me the following morning, I had already determined what the email meant and what we were going to do with it. I did not need to describe what reading it had felt like. What mattered was what came next. Cedric walked through the legal interpretation first. He said that in isolation, pulled from its context, stripped of its timeline, the email could be read as a routine inquiry. Removing an incapacitated trustee is a recognized legal procedure. A person could argue Harlan was simply educating himself about trust succession processes. Cedric said that argument existed and that Harlan's team would make it. Then he said what dismantled it. The email was sent 4 months before Wendell died. At that point, Wendell was still the active trustee. Still competent, still managing the business, still present. The only trustee whose future incapacitation was strategically relevant to Harlan at that moment was me, not Wendell. Me, the woman who would become sole successor trustee the moment Wendell was gone. Harlan was not researching a legal process. He was researching how to remove an obstacle he had not yet encountered, but was already planning around. Fitzgerald filed a supplemental discovery motion, requesting every communication between Harlan and that unidentified contact. Harlan's team objected within 24 hours. Cedric had anticipated it. He filed a response the same afternoon, invoking the crime fraud exception, the legal doctrine that can remove privilege protections from communications made in furtherance of potential fraudulent or criminal conduct. Cedric was careful in whistling from the beginning. He was not accusing Harlan of a crime in open court. He was arguing that the surrounding facts justified judicial review of the communications themselves. The hearing was the most charged courtroom exchange of the entire case. Gresham argued privilege carefully and professionally. He said the emails reflected preliminary legal inquiry, not criminal planning. He warned the court against treating aggressive estate positioning as evidence of unlawful intent. He argued that piercing privilege protections required more than suspicion, and that opposing counsel was attempting to convert circumstantial timing into misconduct. Cedric did not overreach in response. He walked the court through 3 specific anchors: the language of the email itself, its timing relative to Wendell's illness, and the financial positioning already documented in the discovery records. Each anchor connected to the others. Together they built a picture, not of a man researching legal procedures in the abstract, but of a man constructing contingency plans around his brother's death while his brother was still alive. Judge Dupree asked more questions than either attorney expected. He wanted timelines clarified. He wanted the discovery sequence reconstructed precisely. He stated openly that Georgia courts did not pierce privilege casually, and that the standard required more than strategic suspicion. He said the court was not making any criminal finding at this stage and would not treat the motion as proof of wrongdoing simply because troubling language existed in an email chain. Then he ordered the disputed communications submitted to him for in-camera review under seal. The courtroom shifted when he said it. Not dramatically, quietly. The way rooms shift when experienced lawyers understand a judge has moved from listening to examining. Judge Dupree said he would take the matter under advisement. I walked out of the courtroom into the corridor and turned to find Dolores Treadwell standing a few feet away. 84 years old, steady on her feet without assistance. watching me with the eyes of a woman who had lived long enough to see everything this family had ever done to itself, and had arrived at a place beyond surprise. This was the first real conversation we had exchanged since the lawsuit began. She did not apologize for her son. She did not offer me the performance of a mother's distress. She looked at me the way women of her generation look at you, when they have decided words cost something, and they intend to spend them carefully. She said she knew what Harlan was. She said Wendell had always known too. She held my gaze for a moment and said, "My boy built something real. Don't let Harlan burn it down just because he never learned how to build." Then she walked away. I did not cry. I pressed my hand flat against my sternum, the same way I had been pressing it since the morning I lost Wendell, and I held whatever she had just placed there in place until I could breathe around it properly. 2 days later, Judge Dupree issued his ruling. After reviewing the communications privately under seal, he found sufficient basis to apply the crime-fraud exception for the limited purpose of discovery production. Harlan was ordered to produce all related communications with the unidentified contact within 10 days. Gresham immediately requested an emergency recess. I watched Harlan's face from across the courtroom. Since the morning he walked into my house, he had operated from a position of absolute certainty that the rules bent for men like him, that preparation was something other people needed, that was simply a matter of showing up with enough confidence. It was not holding now. For the first time since this began, I saw something move across his face that looked like actual fear. Waiting is its own kind of discipline. Not the waiting of a woman who does not know what is coming. That kind hollows you out. This was different. This was the waiting of a woman who had done everything correctly and was now trusting the work to do what work does when it has been built properly. 10 days before Harlan had to produce those communications. 10 days of letting the case breathe while the pressure built on the other side of it. I called Paulette one afternoon and sat on the back porch while we talked. The chair beside mine was empty the way it had been empty for months, and also not empty, the way certain absences never fully become absences. Wendell used to take that chair every Sunday morning with his coffee going cold because he always let it go cold, always too busy talking or watching the yard, or just sitting in the particular quiet way he had. I had stopped trying to separate missing him from everything else. It lived in the same space as breathing now. Then Francine called. Not Harlan. Francine. Her voice sounded controlled, in the way voices sound when the control is recent and fragile. She asked if we could meet privately. I told her I would not discuss the case without attorneys involved. There was a long silence on the line before she said she was not calling to negotiate anything. She said there were things I needed to see before Harlan's production deadline arrived. I told Fitzgerald's office that evening that Francine had requested contact. Fitzgerald advised against any substantive discussion outside counsel presence, but said that if Francine voluntarily provided independent materials without solicitation, the safest thing I could do was document the interaction immediately afterward and avoid discussing strategy, testimony, or settlement. So I met her. We met at a quiet restaurant in Buckhead. She arrived looking like a woman who had not slept properly in weeks. Not disheveled. Francine was never disheveled, but worn in the way that careful grooming cannot fully conceal. She did not open with an apology. She opened with a question. She asked me how long before Wendell died Harlan had been planning this. I told her to say what she came to say. She told me she had believed they were coming to contest an inheritance. A disputed estate, ugly, difficult, the kind of family conflict that tears people apart but stays within the recognizable boundaries of family conflict. She said she did not know about the emails to the property brokerage. She did not know about the financial maneuvering around Wendell's illness. 3 weeks into the lawsuit, she had found documents at home, communications she was never meant to see, and what she read had changed her understanding of the man she had been living beside. She slid an envelope across the table. Inside was a printed email chain dated 6 months before Wendell died. Harlan and an unidentified contact, discussing the logistics of challenging a trust structure under Georgia law in the event that the current trustee became. And these were Harlan's own words, no longer a viable obstacle. I picked up the envelope. I did not thank her. I asked her one question. Does Harlan know you're here? She said no. I told her to go home. I told her to think carefully about what her obligations were, to her husband, and to the truth. Then I finished my water and I left. The following morning, I brought everything directly to Fitzgerald. His response was measured but immediate. He did not reach for the envelope. He went very still, the specific stillness of a professional managing serious concern, before it becomes something harder to contain. He told me we had handled the situation correctly enough to avoid immediate exposure, but barely. Then, he explained why. A party on the opposing side voluntarily approaching me with documents was one thing. Any appearance that I had encouraged, coached, or strategically directed that contact was another. He said opposing counsel would look for any basis to characterize the interaction improperly if they learned about it later. He told me that from this point forwards, every contact involving Francine went through counsel only. I absorbed it without argument because he was right. It was the one place where my preparation had a gap. Wendell had planned for Harlan, had anticipated every move, every angle, every door Harlan might walk through. But he had not planned for Francine arriving at a restaurant in Buckhead with an envelope and a conscience. That was the one variable neither of us had seen coming. 3 days before the production deadline, Fitzgerald received a filing from Harlan's team. They were claiming a significant portion of the requested communications had been lost in a server migration. Cedric read it, set it down, looked at me in the same unbothered tone he used for everything and said, "He destroyed evidence, and he wasn't careful enough about how he did it." I asked Cedric what evidence destruction meant in the context of active litigation. He told me no softening, no dramatizing. He laid it out the way he laid out everything, as a set of facts connected to a set of predictable consequences, spoken in the tone of a man who has watched this particular sequence of events play out before and found it neither surprising nor complicated. The legal term was spoliation. When a party destroys evidence after a court has ordered its production, the consequences move in 3 directions. First, monetary sanctions assessed against the offending party personally, not their legal team. Second, adverse inference instructions to the jury, meaning the jury would be permitted to assume that whatever was destroyed would have been damaging to the party who destroyed it. Third, in cases of deliberate and documented destruction, referral to the appropriate authority for criminal investigation. The dividing line between consequence 2 and consequence 3 was always the same question. Was the destruction intentional or accidental? Harlan's server migration claim was his answer to that question. Cedric's answer was the metadata. A technical consultant we brought in specifically for this recovered the metadata from the original email thread. What it showed was not ambiguous. The communications had existed in full before the court issued its production order. They had been accessed from Harlan's personal device multiple times during the active discovery period, meaning he had been reading them while the order requiring their production was already in force. They had been deleted in a targeted and selective manner 11 days after the court issued the order. Not during a server migration, not as part of routine data management. 1 thread, 1 deletion window, 1 decision. Cedric filed a formal sanctions motion and presented the metadata findings to Judge Dupree in open court. Gresham attempted to argue the deletions were routine data management, standard maintenance that coincidentally affected the files in question. Cedric asked one question in response. He asked Gresham to explain why routine data management would selectively remove only the communications subject to the court's production order, while leaving every other email in the surrounding threads completely intact. The surrounding traffic, sent and received from the same account during the same period, was untouched. Only the ordered communications were gone. Gresham did not have an answer that held. Judge Dupree did not ask him to fine. The sanctions order was issued against Harlan personally. The judge instructed that if the case proceeded to trial, the jury was to draw an adverse inference from the missing communications, to treat their destruction as evidence that their contents would have damaged Harlan's case. The order was entered into the public court record, where it would remain regardless of how the litigation resolved. I watched Harlan across the courtroom when the ruling was read. He looked at me. I did not look away. I had been watching this man since the morning he walked into my house carrying his certainty like a credential. The certainty that he was owed something, that preparations for people who did not have his kind of confidence, that the outcome of things was determined before the work of determining them began. I had watched that certainty hold through every setback this case had delivered. It was not holding now. He looked like a man who had run his own calculation for the first time with accurate numbers. The answer he had arrived at was not the answer he had been living inside. That evening, Gresham submitted a formal settlement offer to Fitzgerald. Harlan would drop the lawsuit entirely in exchange for my agreement not to pursue sanctions or counterclaims. Fitzgerald brought it to the kitchen table. I read it once, I set it down. I looked at Fitzgerald and said, "Tell him no." There is a particular feeling that comes when you stop defending something and begin moving towards something. I had been patient for a long time. I had been still while the case assembled itself the way Wendell and Cedric designed it to assemble, methodically, irrefutably, one documented layer at a time. I had let Harlan file. I had let him overreach. I had let him destroy evidence and ignore his own attorney's counsel and demonstrate in open court exactly who he was. Patience had been the strategy. It had worked. Now I told Fitzgerald and Cedric to file. The countersuit was comprehensive. I want to walk through each count the way I composed them, because each one represents something Harlan chose to do and something he was now going to answer for. Count 1. Attempted wrongful eviction from a legally owned property. He came to my door and told me I had 30 days to leave a house that transferred to me automatically the moment my husband died. That was not a misunderstanding. That was a calculated attempt to remove me from what was mine. Count 2. Tortious interference with Treadwell Property Group's business relationships. Harlan had contacted Wendell's commercial, identified himself as the new property manager on unofficial letterhead, and directed rent payments to a personal account. He had deliberately misrepresented ownership to people who had built working relationships with this company over years. Count 3. Conversion. The rent payments he collected before the court's injunction stopped him. Money taken from properties he did not own. That money had a paper trail, and the paper trail ended at his personal account. Count 4. Sanctions and all legal fees resulting from the evidence spoliation. Assessed against Harlan personally. The public court record already documented what he had done. This count simply attached a financial consequence to what the judge had already confirmed. Count 5. Fraudulent misrepresentation to third parties. The false ownership claims made to banks, business partners, and tenants across the full course of the litigation. Every conversation where Harlan had presented himself as the owner of an estate that belonged to me. Fitzgerald asked about intentional infliction of emotional distress. Cedric told him it stayed off the filing. Georgia courts required conduct so extreme, it exceeded all recognizable bounds of decency, a standard that was unpredictable and difficult to quantify. The 5 counts they had were clean, documented, and winnable. 5 strong counts made a stronger case than 6 uneven ones. Filing day was quiet. Fitzgerald laid the documents on the kitchen table and watched me sign each page. When I finished, he sat back and was quiet for a moment, in the way a man is quiet when something he has witnessed has changed his understanding of what people are capable of. Then he told me Wendell would be proud. I told him, not unkindly, that Wendell would say, "I took long enough." The countersuit was served to Harlan at his home. Paulette told me later that it was Francine who opened the door and accepted the documents. I sat with that image for a while. A woman standing in her own doorway, receiving legal papers filed against her husband, papers that existed because of choices he made long before either of them walked into my living room. I thought about Francine in that restaurant in Buckhead, about the envelope she slid across the table and what it had cost her to slide it, about what it means to spend years beside someone and discover that the person you believed you knew had been running a calculation you were never shown. I set the image down carefully. It was too heavy to carry and too significant to drop. Within the week, Gresham filed a motion to withdraw as Harlan's counsel. Irreconcilable differences regarding case strategy. He was done. Harlan now had to find a new attorney willing to take a case carrying a public sanctions order, a countersuit on 5 documented counts, and a client who had ignored every settlement recommendation his previous counsel made. Harlan found new counsel within 10 days. Cedric reviewed the first filings from the new attorney and gave me his assessment without editorializing. The arguments were thinner, the citations less targeted, the legal framing less precise than Gresham's had been. A competent attorney reviewing this case file would have asked difficult questions before agreeing to take it. Cedric's professional opinion was that Harlan had not given this one the complete picture. That was Harlan's pattern, presenting the version of events where he was still winning and expecting everyone around him to work from that version. The new attorney was working from a version that no longer existed. Within the same week, Francine retained her own counsels separately. Her attorney contacted Cedric to discuss the scope of her personal liability in the tortious interference count. Cedric's response was measured. Francine's exposure depended on her level of documented participation and what she was prepared to clarify about the timeline of Harlan's planning. He did not close the door. He named the terms under which it could open. I noted this without drama. Francine had made her choice in that restaurant when she slid an envelope across the table to the woman her husband was suing. She was living inside that choice now, and the consequences of it were hers to navigate. Then, Dolores called. She had taken the public court filings to a retired judge from her church, a man whose opinion she trusted and whose reading of legal documents she respected. He had confirmed what she already believed. She told me she intended to submit a written statement to the court, attesting to the nature of Wendell's and my marriage. 31 years of documented partnership, shared financial building, mutual decision-making. She would attest to her personal knowledge that Wendell had made every estate planning decision in full mental capacity, without pressure from anyone. It was not a legally decisive document. But in Atlanta, in a community where the Treadwell name carried 30 years of weight, a mother's written testimony against her own son's narrative was something a court ruling could not replicate. Paulette came over that evening. We sat on the back porch with the outdoor lights on and the Atlanta night moving around us the way it does. Warm, unhurried, indifferent to the particular weight of what was happening inside this house. I was quiet for a long time. Paulette did not fill the silence. She had known me long enough to understand that some silences needed to finish themselves. Then I cried, not from fear, not from any doubt about how this was going to end. From the weight of 6 months of being strategic in a house where Wendell's reading glasses were still on the nightstand exactly where he left them. From the particular exhaustion of missing someone every single day in the middle of fighting for everything he spent his last months making sure I would keep. I told Paulette he knew I could do this. I just wish he could have seen it. She did not tell me everything happened for a reason. She did not tell me he was watching. She put her hand over mine, and we sat there until the crying finished, which was the only correct response and the only one I needed. 2 days later, Cedric called. He told me the Fulton County District Attorney's Office had requested copies of the sanctions order, the discovery timeline, and the metadata findings connected to the deleted communications. The referral had been triggered automatically after Judge Dupree's written sanctions ruling entered the public record with findings describing targeted deletion following an active production order. Cedric was careful with his wording. He said the DA's office was not filing charges. They were conducting a preliminary inquiry, determining whether the documented conduct warranted further review by their white-collar and obstruction unit. At this stage, they were gathering records, not announcing conclusions. Then he explained why it mattered anyway. The civil sanctions order already established that evidence destruction occurred. The remaining question was whether prosecutors believed the destruction rose beyond litigation misconduct into intentional obstruction. The metadata recovery, especially the timing of the deletions during active discovery, was what moved the matter onto their radar. Cedric read me the notification in full. Then he asked if I had any questions. I was quiet for a moment. I said, I think that covers it. I want to be precise with you about what the criminal inquiry meant. It was not a conviction. It was not an indictment. It was a preliminary investigation. The DA's office determining whether the evidence already documented in the public court record warranted moving toward formal charges. I had no control over its direction, and I was not counting it as a victory. What I understood was simpler than that. Its existence changed the architecture of everything Harlan was still trying to build in the civil case. His new attorney apparently made that very clear. Every deposition Harlan gave in the countersuit proceedings, every filing his counsel made, every statement he put on record, All of it was now potentially visible to the criminal inquiry. The two proceedings were legally separate. They were not insulated from each other. Anything Harlan said in one room could be examined in another. His attorney, working from whatever version of events Harlan had provided, now had to advise his client that continuing to litigate aggressively was not a strategy. It was a way of building a second case against himself while trying to survive the first one. The full scope of Harlan's financial picture was now public record, available to the court, to both legal teams, and to anyone in Atlanta who was paying attention to the Treadwell name. Maximum credit lines. A second mortgage signed while his brother was in treatment. Investment accounts that should have represented decades of careful management, nearly emptied. The man who came to my door 6 months ago in a dark suit with a leather briefcase and the posture of someone asserting a birthright, that man had been performing. He did not want the Treadwell estate only because he believed it belonged to him. He wanted it because without it, he was drowning. He had looked at everything Wendell and I built across 31 years, and he had seen a life raft with someone else's name on it. I sat with that understanding for a while, not with triumph, with something more complicated than triumph. Grief, maybe. Not for what Harlan had done. I had no grief left for his choices. For what Wendell had lost in a brother long before he lost anything else. Two men who came into the world the same day, who shared a face and a name and a family table, who could have built something alongside each other. Wendell had known what Harlan was for most of their adult lives and had loved him anyway. At a careful distance, the way you love someone you have accepted will never be who you needed them to be. That was its own kind of loss. It had nothing to do with the lawsuit, and everything to do with what the lawsuit had made visible. Francine's attorney submitted a written statement on her behalf. It clarified her limited involvement in Harlan's business decisions and confirmed she had no knowledge of the pre-death communications until they surfaced in discovery. She was substantially removed from the financial exposure in the countersuit. She and Harlan had not appeared together publicly in several weeks. I noted this without comment. The final pretrial conference was brief and pointed. Judge Dupree addressed Harlan's new counsel directly. He told him the court had significant concerns about the plaintiff's conduct across the full course of these proceedings. The unauthorized tenant contact, the revenue collection during active litigation, the evidence destruction now documented in the public sanctions order. He strongly encouraged both parties to resolve the matter before trial. He was not subtle about what his assessment of the likely trial outcome was. That evening, my phone rang. Unknown number. I almost did not answer, then I picked up. The voice was Harlan's. In 31 years of being his brother's wife, he had never once called me directly. I sat down without thinking about sitting down. He said my name once. Then he said, "How much?" I did not negotiate on that phone call. I told Harlan to have his attorney contact Fitzgerald with a full settlement offer by end of business the following day. Then I hung up. I sat in the quiet house for a while, not thinking about numbers or legal strategy or what the next morning would bring. Just sitting. Then I went to bed. I slept better than I had in months. The settlement offer arrived the following afternoon. Fitzgerald and Cedric sat with me at the kitchen table and walked through it. The figure was significant. They told me I could take it and be done, that by the realistic standards of what was recoverable at trial, this offer was reasonable, and that trial, regardless of how strong a case was, always carried uncertainty. Outcomes depended on variables no one could fully control. I asked what happened if we countered. Cedric told me the countersuit was well documented and strong. The spoliation sanctions created personal financial exposure Harlan could not litigate away. The criminal inquiry, though completely independent of the civil proceedings, made his team acutely motivated to reach a resolution that stopped the accumulation of his public record. We were not negotiating from need. We were negotiating from position. I told them to counter. The negotiation took 4 days. I did not spend those 4 days watching the clock or waiting by the phone. I walked in the mornings. Long walks through the Atlanta neighborhoods Wendell and I used to drive through on Sunday afternoons, talking about nothing important and everything that mattered. I had dinner with Paulette one evening. One afternoon, I drove to the cemetery and stood at Wendell's grave. I did not talk to him. I just stood there in the Georgia air, And let the ground say what it says when you stand in a place that holds someone you loved. Some things do not require words. That was one of them. One afternoon, I asked Cedric to show me the complete financial picture of what Harlan had spent. Not what he owed me, but what he had cost himself. Cedric laid it out without commentary. The maxed credit lines, the second mortgage, the investment accounts emptied over 2 years of positioning and preparation, the legal fees across 2 attorneys, the sanctions assessed against him personally, the settlement figure he was now being forced to pay to finances that had been deteriorating long before he ever knocked on my door. I looked at those numbers for a long time. I did not feel what I expected to feel. I had imagined this moment carrying something closer to satisfaction, the clean feeling of a balance being restored. What I actually felt was a particular sadness that had nothing to do with forgiveness and nothing to do with sympathy. It was the sadness of watching a man spend absolutely everything he had trying to take absolutely everything I had, and understanding that this was the whole of what his brother's death meant to him. Not grief, not loss, an opportunity he had been calculating since before the loss was final. I thought about Wendell loving this person. I thought about 2 men sharing a birthday and a face and a family name, and then spending their lives going in directions so opposite that one of them ended up here. The final settlement was reached on the 4th day. Harlan paid full restitution for every rent payment collected before the injunction. He paid my complete legal fees, the full cost of defending his lawsuit and prosecuting the countersuit. He paid a negotiated damages figure covering the tortious interference and the fraudulent misrepresentation claims. The total I will not name precisely. I will say only that it was enough to do what Wendell and I had talked about doing for years and never formalized. I am calling it the Treadwell Foundation, estate planning education for Black families in Atlanta, helping people build what we built before the crisis arrives, not after. Harlan dropped every original claim against the estate. The Treadwell Family Trust, everything inside it, remained entirely and permanently mine. The criminal inquiry continued on its own track. I had no part in where it led. The morning after the settlement papers were signed, Fitzgerald called and said he needed to say something in person. He came to the house. He sat down at the kitchen table and looked at me for a long moment. Then he said, "Nancy, I need to ask you something. When you picked up that pen in the beginning, were you ever afraid?" "Yes." I tell Fitzgerald yes before he has finished settling into his chair. He asked if I was ever afraid, and the honest answer is yes, every single day for 6 months. I want him to understand what I was afraid of, because it matters that he understands it correctly. It was not Harlan. I had prepared for Harlan. I had spent 31 years watching my husband navigate what it meant to love a brother who measured himself against everything Wendell built and found himself wanting every time. I knew how Harlan moved. I knew what he wanted and how he would come for it. Harlan I could manage. What frightened me was doing it without Wendell. Making decisions that size. In a house that still had his reading glasses on the nightstand, exactly where he set them down, the last evening he was well enough to read. His coffee mug still in the cabinet, the heavy one he refused to replace because he said it held heat longer, and he was right, but I never told him that. The particular smell of him that grief had not yet managed to reach, that lived in the fabric of things, that I would encounter without warning in the middle of ordinary moments and have to find somewhere to put. I was afraid of being strategic in a house that still felt like him, of making the right moves for the right reasons, while missing him so much it lived in my body like weather. I tell Fitzgerald about the last real conversation Wendell and I had before he became too ill for long exchanges. He made me sit at this kitchen table, this same table, with the full document portfolio spread open in front of us. He walked me through every page, every account, every trust provision, every step of the acknowledgement procedure, twice, until I could walk him through it from memory without looking at the paper. He was thorough even then, especially then. When he finished, he closed the folder. He held both my hands on top of it, his hands over mine, the folder underneath. 31 years of building something together, compressed into that one point of contact. And he looked at me the way he had been looking at me since 1992. He said, "You built all of this with me. Don't let anyone tell you otherwise." I kept that moment in my chest like a stone for every day that followed. Every courtroom, every filing. Every morning I woke up, and the house was quiet, and the weight of what I was carrying threatened to become more than I could hold upright. I pressed my hand flat against my sternum, the way I had been pressing it since the morning I lost him, and I felt the weight of his hands on mine. And I kept going. Fitzgerald is quiet for a long time after I finish. There is nothing to add to what I just told him, and he is wise enough to know it. The estate looks like this now. Treadwell Property Group is still operating. I brought in a general manager I trust completely. But I stay involved, not because the business requires me to, but because Wendell spent 22 years building relationships with people who knew his name and trusted what it stood for. I am not ready to hand that entirely to someone who never sat across a table from him. The Treadwell Foundation filings are already underway. Cedric is structuring it properly as a Georgia nonprofit, the legal architecture clean and correct from the beginning, the way we did everything. It will launch within the year. The house stays. I repainted the front room last month. Wendell had wanted navy for 11 years, and made his case every time we walked past a paint sample. I wanted sage green, I chose green. I sit in that room in the mornings with my coffee now, and I tell him he was wrong about the navy. I think he would have come around eventually. He usually did when it mattered. I want to speak directly to every woman watching this who has ever been told that grief makes you a target. Every woman who has watched someone come through her door with documents and lawyers, and the quiet certainty that loss had made her manageable, that her mourning had created an opening, that she was too broken, too soft, too distracted by pain to protect what she and her husband spent a lifetime building. What Wendell left me was not only the house, not only the business, not only the trust or the legal architecture he built across 14 months of treatments and late nights and yellow legal pads at this kitchen table. Those things matter, but they were not the gift. The gift was his belief in me, absolute, unshakable, signed, witnessed, and notarized in every decision he made in the last year of his life. He was right. He was always right about me. I just had to be still enough to remember it.